Hey everyone, I'm Garrison, Deputy General Counsel for Crypto at Robinhood, and I'm looking forward to the conversation today.
Can I grab that? Yeah. Hey, I'm Chris Giancarlo, former chairman of the Commodity Futures Trading Commission, and Vanderbilt Law School, class of 1984.
Hi everyone, I'm Matt Solomon. I'm a partner at Cleary, Gottlieb in DC. I do SEC enforcement, CFTC enforcement, and some civil litigation work.
Justin Slaughter, VP Regulatory Affairs at Paradigm, which is a frontier venture capital firm, also alum of the CFTC and SEC.
Lee Schneider, I'm the General Counsel at Ava Labs. We work mostly on the Avalanche blockchain, general nuisance around the world, and not an alum myself, but my nephew went here, so I am sort of close.
So hi everyone, and I'm your moderator today. I'm Lisa Pinheiro. I'm a partner with Analysis Group, and I'm a fraud detection expert, acting as an independent expert on Kalshi surveillance and market integrity committee. So lots of interesting discussions already for me this morning. I wanted to jump in maybe talking about first what makes these markets really hard to regulate. And maybe, Chris, I mean, if we can start with you and maybe transition for what we just heard this morning. I mean, we just talked about this impressive and ambitious agenda this morning that covers a number of things, from prediction markets to perpetuals to a joint taxonomy. And can you tell us a little bit more about your perspective on this, since you're saying, you know, Chairman Selig is his own man, and you know, how this new world?
Yeah, you know, a number of people have asked me, well, how will the CFTC under Chairman Selig be able to make its rules durable without a full commission there? And I think it's tremendously commendable that even without a full commission, the chairman is committed to rule writing in normal order and comment periods of longer than 30 days, back to the norm of 60 to 90 days. And it's interesting that, in fact, the SEC under its previous administration had the commissioners in place that could have done rulemaking and chose not to. You know, it's a luxury to have a full commission. It used to be the norm. It's less so today. But agencies need to move ahead and do what they're charged to do, and can't make excuses of, oh, we don't have the resources to get things done. Again, I hear that all the time. How can the CFTC do what it has to do without the resources? Well, there's actually nothing in the statute that says you're supposed to regulate unless somehow you don't have enough resources, in which case you can climb back in your shell and not get things done. Or you don't have a full slate of commissioners, so you can climb back and not do rulemaking, which was the decision of the SEC not to do rulemaking. I think it's commendable that Chairman Selig is bringing the CFTC back to whatever the resource allocation, whatever the commissioner structure, to do its job. That is rulemaking, that is overseeing its markets, it is surveillance, and all the things that you just heard in the last 40 minutes that Chairman Selig has pledged to do.
Thank you. And so let's go into perpetuals then. And Coy, I'll start with you. So Robinhood offers the perpetuals in Europe. So what is it about the U.S. system and infrastructure that makes it so hard to offer them here?
Yeah, so I like to maybe parse the perps out for a second and say the U.S. is just a different animal, right? Like, big picture in crypto, the big problem of offering stuff in the U.S. is there's no federal framework, obviously, right? So that's why we really need the CFTC to be given authority under clarity. We're obviously very, very supportive of the federal legislation going through. Right now, different crypto assets are available to customers in some states, but not other states. Staking is available in some states, but not others. That's a ridiculous outcome. That's a bad outcome for American consumers with no added benefit, right? So that's something that we are actively fighting for, and we're hopeful that legislation gets over the finish line, but we're hopeful and grateful with the dynamic leadership in the CFTC and SEC that even if legislation does not happen, enough of a framework can be put in place that there can be something that moves forward. Perpetuals is a little bit different of an animal, right? So in Europe, MiFID allows for perpetual derivative contracts to trade. So we offer crypto perps in Europe under MiFID, under our MiFID licensed entities. We have 10 contracts that are up and running, and we think that is running really well, and our retail customers in Europe are using the products. They like it. They get 10x leverage. They really like it. It seems to be working. There's a lot of consumer protections involved. We think that model works really well, and we're excited to work here in the U.S. as the CFTC stands up a program for regulated perps in the U.S. We think there's a lot of promise there, and it's really just the change in leadership. You didn't have that in the past, and now you have leadership that's willing to allow industry to come in a responsible, safe way. They're taking their time. They're getting input. That's the way to do it.
Wonderful. And maybe as a follow-up, so how do you manage the fact that you're offering products that sort of associated with different regulators? And do you have to treat them all separately? Do you think of it as a whole group? Like, how do you?
Yeah, we think of our products based on the customers that we're selling to in that jurisdiction, right?
Mm-hmm.
We are in a heavily regulated industry that's regulated differently in each jurisdiction. So depending on the product, depending on the jurisdiction, I have a different main regulator. You know, in the U.S., I'm always thinking about the New York DFS. I don't leave the room without their permission, right? It's not the same in Europe. I do the same, but with Bank of Lithuania and our friends in Slovenia and Luxembourg as well. So it's just a highly dependent jurisdiction-specific process.
So still very fragmented.
Yes.
Thank you. And maybe, Lee, let's go to you. And so thinking about permissionless blockchain infrastructures and your work at Ava Labs, so how are these ecosystems thinking about, compliance issues when you're in a framework that was designed for intermediated markets?
I'd say we try not to think about compliance at all. No, just kidding. Look, I think one of the things that Coy said in particular is very important, is that you need responsible actors to be coming in and doing these things. And by the way, you can be a responsible actor even if you don't know what the regulatory regime precisely is. We all spend a lot of time advocating with Congress and with regulators on what we think the regime should be. But the basis for that is that we arrive at reasonable conclusions, arguing by analogy, thinking about similar use cases, et cetera, to come up with what we think is a reasonable way to proceed. And so when you look at layer one blockchains, obviously that's a different animal. The transaction layer there is very simple. But as layer ones start to get specific for specific use cases, they look a lot more like applications than just a layer one. As they get integrated into a larger tech stack, they start to look at like all kinds of markets and whatnot. And so from our perspective, most of the job is about coming to what we think are reasonable, defensible conclusions when we're implementing something new. And we think that's a very important part, even when the regulations are clear, or mostly clear, because you're going to get that edge case where it's not quite covered, or you could read the statute this way or that way, et cetera, et cetera. And so there's a lot of room for that kind of good, solid thinking, we believe.
And do you believe all of this compliance can be embedded in the protocols, or is there limits to that?
I personally think there's limits to that. I think trying to program a protocol for today and trying to speculate about what it will look like tomorrow and how people will use it tomorrow is a very difficult thing to achieve. And so you do need the ability to have the protocols grow and change. That gets back to trying also to ensure that you've got more good actors than bad actors in the protocol, because you want people who are trying to comply by default rather than trying to cheat by default.
Thank you. So maybe Matt, do you want to go next?
Sure.
And so I had a question for you, but this sort of updates ever, is even this morning. But I wanted to ask you about your view as a litigator about the different conclusions that the courts have been reaching on prediction markets and, state versus federal authority. Where do you think this is all headed? Are we done?
Probably to the Supreme Court, and we got a step closer today with a favorable judgment by the Third Circuit Court of Appeals, the first Court of Appeals decision to weigh in on some of the questions around the CFTC's preemptive authority in relation to prediction markets, and it was a positive outcome for the CFTC and for the country, frankly, because you get some clarity, at least from one circuit. For me, it's a bit of a whipsaw because I spent the last 5 years litigating against the SEC on Howey issues, where the agency was doing everything it could to impede us in litigation. This is a different situation, much more favorable in the sense that, look, the states have attacked DCMs, including FCMs as well, Robinhood, Crypto.com, who we represent, Kalshi, obviously. And there's big money behind those attacks, and they've had some success at the district court level. And fortunately, in this case, the CFTC has stepped up and recently filed an amicus brief making clear its position on the issue, that it has exclusive jurisdiction pursuant to the CEA and the amendments over trades on DCMs. I think that is clearly the law. That is clearly what Congress intended. It's backed up by the statute. But they've gone a step further in that they have actually now sued 3 states, along with the Department of Justice, Illinois, Connecticut, and the state of Arizona. Now, why Arizona? Because Arizona has commenced a criminal investigation of Kalshi, as you well know, because I know you sit on their surveillance board. So having an agency put its money where its mouth is, and I commend Chairman Seelig and others, and actually putting their position out there in federal court. And there's a history for this. The OCC has done it. Other agencies have done it. There's nothing new about it, but it doesn't happen as much as it should. But having that wind at our backs now in our ongoing litigation, having the key regulators speak to the intent of Congress, to their intent as the chief regulator in this area, has been incredibly helpful. But I do think that these cases aren't going away. There are some split determinations in the district courts. We've got one favorable decision of the Third Circuit. The Fourth Circuit should be soon to follow, then the Ninth. And I think ultimately, circuit split or no circuit split, the Supreme Court's going to have to resolve some of the key issues on this preemption issue, and I expect that to happen in the next couple of years.
Speaking of preemption, can I jump in on this?
Absolutely.
Can I preempt before we go to Justin? Because I also filed an amicus brief in the Eighth Circuit on this, and actually over the weekend penned an op-ed, which I'm hoping to get published in the next few days, entitled, "How do you cut a 7-layer cake?" The problem I see it in very simple terms is we're trying to cut a 7-layer cake by a layer. We're trying to say, you know what sports are with the states, but these other layers of elections or economic events, those might be federal. That's the wrong way you slice a 7-layer cake. You slice a 7-layer cake from top to bottom. The real decision or the real distinction should be, is it a marketplace? How do you determine a marketplace? In a marketplace, the participants are price takers and price makers. In these state casinos, there's only one price maker, that's the casino. It's like a retail establishment where the prices are listed. Everybody can come in and take the price or leave the price, but they can't make the price. Those have traditionally been regulated at the state level. Why? Because like retail establishments, you need to make sure the establishment treats its customers fairly, but they're not marketplaces. As Chairman Seelig said earlier, the federal government has clearly stated its intention for federal regulation of marketplaces. These prediction markets are two-way marketplaces. They should be regulated at the federal level. Let's cut the cake the right way, not somehow trying to say sports are one thing, everything else is another. That's not going to work. The question is it a marketplace?
Yeah, I'll just follow up on that. I think in many ways, this gets at the key issue here, which is that if you're having a court decide things, we saw this with crypto, we're seeing prediction markets, we're going to see it with AI next. The court cannot be engaging in jurisdiction with a scalpel. It's too hard. It's not their job. They answer the question in front of them. So they actually cut the cake with a meat cleaver. That is a risk for everybody because you don't always like how that goes. Congress is the only entity that can actually really whittle out exactly how this all works. I would also focus on one other thing, though, which is that, I'll say this with praise of Chair Seelig, in the final analysis, the most important thing regulators do is decide. They get to decide what to do because that then closes off other choices and creates downside risk. Over the last 15 years, I think we in America have had an inability to actually make hard choices on financial regulation, in part because of the lagging debt of the financial crisis. The best attack on how we got here came from a European who, as usual, started with that great line, "You Americans, only good things can happen if you hear that." You Americans, they said this in 2023, you think you have perfected financial regulation with Dodd-Frank. You, therefore, are free to change anything. And as a result, all these problems keep piling up. What we now have is an effort to deal with all the things that developed, crypto, prediction markets, perpetuals, which are part of that, DeFi, stable coins, in these first few years. And so far, it's going well. I do think you're going to see, unless there is real clarity from the courts in a very positive direction, the same mistake yet again, though. Because even if the Supreme Court comes through and says this is all legal, that doesn't end the game. Congress can still act. In the end result, I think we saw this with crypto, we're seeing it with prediction markets, the final solution to clarity has to be legislation. That won't change because of any court cases, even though right now, if I was betting this case this morning, the odds that prediction markets get a stonking win in the courts went up dramatically.
And so maybe stay on you, Justin, for a second. Then you were saying if the legislation passes, but even if that happens, it will take years to implement. So what's happening in the middle?
I mean, now I will actually not attack the chair, but I will aim at his chief of staff. Technically, there's still a rule not finished under Dodd-Frank at CFTC. There's one. Almost everything else is done. It takes a long time, but the way it works is in the first few years you make massive progress. Most of Dodd-Frank at CFTC was finished by 2016 when then Commissioner, now then Chair Giancarlo came in. Margin was still to be done, capital, position limits, but the vast bulk was done in 2 to 3 years. You can accomplish a great deal by going after the big, gigantic parts of the rules quickly. Then there's a lag. In the interim, cuts guidance, it cuts industry norms. The industry gets to decide in some ways how they want to follow the new law, and that sets the stage for the playing field and regulations. You can think about it as kind of Zeno's paradox of regulation. Every year you get half done. You will never get to the end technically, but within 3 to 4 years you've done 90%.
And industry gets a stake in the game. They've got a stake in seeing the outcome come.
Without question.
Yeah, I definitely want a slice of cake after panel is over. Preferably 7 layers, Chris. A couple of points. One is, one of the great things about the way things are shaking out right now is that there's more competition and more different kinds of markets. And I tend to be a pro-competition because I think competition breeds freedom, and that's the kind of stuff that I like. The second thing I would say is it's great for us to be focused on what Congress does and what the regulators do. But I'm going to go back to the point that I made when you asked me my question, which is I do think that we all have responsibility too. If we sit around and wait for the regulators, if we sit around and wait for Congress, we're going to end up with suboptimal situations. And the example I'll point to is Congress will hopefully pass market structure, and quote-unquote issuers of tokens will have clarity about what that means. And my guess is there's going to be about 0 real issuances of tokens going forward because it's just not a thing anymore. I mean, I'm being overly dramatic there, right? But seriously, what was the last super successful token launch aside from Hyperliquid? And that wasn't even super successful when it came out. So we're looking at the world already having changed and going back and fixing problems that are going to be applied retroactively if some people have their way with the legislation. We all need to keep looking forward. We need to keep setting the standards for everybody else in the space, whatever space we're in, because that's really where the decisions are going to be made. Everything's moving too fast for things to be otherwise.
Thank you. So maybe let's stay on that idea, Coy, about moving forward. And so you were mentioning perpetuals earlier, and in Europe, those come with margin limits and suitability checks, etc. How do you think it's coming to the U.S.? And Yesha mentioned the possibility that it might actually only be for institutional investors at first. Do you think that would be sort of an appropriate next step, or is that kind of defeat the purpose?
No, I think these products should be available to retail, right? I mean, Robinhood's mission is to democratize finance for all, so we're interested in bringing products to retail investors, and we think they can use them in a responsible manner, right? So it's not only the innovation side and the access to products that's important from an investor protection, but it's also we want our customers to be protected. We don't want to throw them to the wolves into a product they don't understand or don't know, right? So when I think of perps that come in the U.S., I think kind of systematically in a couple different buckets, right? I think one, what's the onboarding process look like? Do they understand what the product is? Is there good educational materials? I think that's really important, whoever's onboarding these customers. Two, I think they're the clearing aspect of this, right? We was talking about centralized clearing parties. That's one model. A lot of these models, our products in Europe don't have a centralized clearing party. So we have a very interesting liquidation waterfall that's explained in our rule book. It's very long and complicated, but I think there's room for innovation that can still meet today's standards under CFTC regs, as long as there's room for experimentation. And I also think of just transparency. This is going to be a new product in the U.S. The CFTC is going to have an interest in seeing how that trading looks like. There's going to have to be flexibility in providing that data, that oversight to the CFTC and the markets themselves to make sure they're comfortable with that, right? So I think there's plenty of room to find the right space, and it's only a matter of time and calibrating the right way, it seems like.
Great. And maybe to you, Chris, then stay on perpetuals. We talked this morning about how, okay, there's no expiry date, but there's also, the funding rate mechanism. They trade 24/7. Is it fundamentally different?
Well, I can. So first of all, and to Coy's point, one of the things that makes the American market so dynamic compared to other markets is that mixture of retail and professional traders, institutional traders. European markets are dominated, really don't have a big retail component. Asian markets can often be skewed toward retail without a large institutional piece. What makes American markets the world's enviable markets is because of that mixture. So as we explore new marketplaces, we definitely want to make sure we're not siding with one or the other, but we want good, dynamic, healthy markets. In terms of and I thought the chairman gave a very good response to the question of does the different duration or the perpetual nature of these markets present issues. What's made the CFTC so successful is its ability to continue to evolve. We still think of the CFTC from ag point of view, but ag products are less than 10% of what the CFTC does. It may be 90% of its politics in terms of getting funding, right? But it's less than 10%. I mean, markets like interest rate futures are the world's biggest marketplaces. They're enormous. Our oil complex are enormous. These markets we're talking about are fractions of the size of what the CFTC already does very, very well. And I think as taxpayers, as American citizens, we want an agency that is out there always absorbing the new next thing, right? We don't want an agency that somehow either is making merit decisions, we don't like this product, as quite frankly, the SEC did for the last 4 years. We don't like it, so we're going to try to suppress it. We want an agency that says, look, it's already been legitimized by the populace. It's being used, and it's being used overseas. We wanted to bring it on shore by developing appropriate, well-tailored rules. And I'll push back on another thing. Regulation is always put in quantitative terms. Too much, too little, the right. I've always pushed back against, that's not the right way to measure regulation. Regulation should be measured qualitatively. Is it the right regulation to achieve the public purpose, the public policy purpose? Not is it too much, too little. The financial crisis wasn't caused because there was too little, and holding things back is not often caused because there's too much. It's just ill-designed, and the goal has got to be to design the regulation to say, what did the people's elected legislature want to achieve? Let's get the regulation to do that, no more, no less, to do that job.
I want to piggyback on that and agree with two things and disagree with one. To disagree, this one's true though. This is important though. The financial crisis was caused in part by a total deregulation of swaps, which is why neither crypto nor prediction markets has asked for total deregulation. We've learned that lesson. I mean, let's get to that. The second thing I would say is a lot of people ask me, as an alum of both SEC and CFTC, why it's better for the CFTC to run prediction markets and crypto. And the answer is very fundamental. They looked for these markets. They were willing to experiment and learn about them. In 2015, it was the CFTC which held Bitcoin as a commodity when everybody in DC was joking about it. It was the CFTC which involved itself with Predicted and with Kalshi when they were seen as toys. You want that kind of curiosity from a regulator, and I think it goes to the inherent protean nature of the CFTC that's been able to reinvent itself 3 times now. It was founded in the 70s. It was in many ways refounded under Gary Gensler, who was a good CFTC chair. SEC, well, that's different. And now it's being refounded again. And it's because of that they're the best equipped to actually regulate frontier markets. Because if you have a regulator that always sees everything as a particular kind of mid-century security, it will not be able to adapt to the changing times.
Just to build on that, up until the 1970s, every product overseen by the CFTC was something that came out of the ground. It was grown out of the ground, or it flowed out of the ground, but it came out of the ground. It was the CFTC who saw inventions by Dr. Richard Sandor and Leo Melamed to create financial futures that said, you know what, it doesn't come out of the ground, but we can regulate it anyway. And the dollar would have never been able to go off the gold standard and remain the world's reserve currency if the CFTC hadn't said that futures on dollar-based interest rates and currency, we can create markets for that. We can do that. So I entirely agree. Not sure I agree with some of those great CFTC chairs that you pointed to, but otherwise.
Obviously, Chris, you stand alone.
Well, I do my best.
And Justin, do you want to say something about, from the investor perspective?
Yeah, I mean, this is really important. So first off, I'm not an investor at Paradigm. I helpfully work with our investing and research team, which is comprised of people who are often 10 years younger and with 30 more IQ points than I have. But the way to think about investing is you have to first focus on the business model. You have to make sure, does this business make sense? And does it make sense not just for today, but for tomorrow? That's the most important thing. That is what LPs who invest their money with you ask for, I'd say. In general, the job of policy is to look not at individual companies, but to look at the ecosystem, to look how does this fit with the world as we think it will develop. So it's a different task, and it's one that I really enjoy, obviously. But when people ask, how do you invest as a policymaker, I'm like, you're asking the wrong question. The business should focus on business, very much, give unto Caesar. Policy focuses on policy.
Awesome. I want to make sure. How much time do we have left? 8 minutes. 8 minutes? All right, I do want to talk a little about prediction markets. Just before we jump there, Matt, tell us a little bit about, again, now there was a issued joint guidance. Oh, sorry. And I should speak in it too. That would help. So I was saying, tell us a little bit. So in the context of the joint guidance from the CFTC and the SEC for the, digital commodities, tokens, et cetera, and I know you were saying how you worked on that for a while, but do you think that this is going to still be challenged in court, or are we done with that?
I think we're probably done with that in terms of challenges. I think the value of the guidance that's been issued, the joint guidance and also the SEC issuing its own guidance and the CFTC, is obviously putting market participants on notice about what the do's and don'ts, various product development, various practices, and also the allocation of responsibilities between the two agencies. Obviously, in this post-Loper-Bright environment, these agency pronouncements are perhaps not going to be given as much weight as they would have given before, but I do think it's important and refreshing for all the reasons that you said. We didn't have this kind of guidance over the last few years. We have it now, so I think that's a positive development.
Awesome. All right, let's jump in about prediction markets for a second. So let me see, in 5 minutes. Well, maybe Matt, let's stay with you for a second. Then again, on the legal side. So we talked earlier about, sometimes suspicious trading happens ahead of certain events. And how well do you think our existing framework and the misappropriation theory works for prediction markets and sort of the broad range of products?
I think for all the reasons that Chairman Selig said, the tools are there for the CFTC. They don't have as much experience, obviously, as the SEC does, naturally, in investigating and prosecuting insider trading cases. They do have the benefit of the body of law that's been developed, federal common law, by the SEC principally and private litigants and the Department of Justice to draw on. I'm heartened to see that you've got David Miller, who's come in as the enforcement director. He's a former prosecutor, has experience investigating, prosecuting insider trading cases, knows exactly how to get that job done, because I think the SROs are important, and you're going to be an important part of that with the surveillance that you're doing for Kalshi. But I think for market integrity purposes, and the CFTC has clearly recognized this, that agency has to have a role. They are staffing up a bit, I think, in the enforcement area. Again, they're going to have some tricky legal issues to deal with because the duty is not necessarily going to be present in every CFTC investigation. There's no duty between two counterparties, as there is in the classical insider trading theory, where you have somebody at a company who is trading against the interests of the shareholders. You don't have that with the insider trading rubric with the CFTC. So that's going to have to be worked around. There's going to have to be agreements identified for purpose of misappropriation or facts and circumstances. I think the CFTC is up to the job. And again, I'm heartened to see that they've got somebody in the enforcement role who knows exactly what he's doing, and that Chair Selig realizes that, SRO is going to be critically important, but I think they're also going to need complementary enforcement efforts and guidance by the CFTC, and I expect that's going to be forthcoming.
I will note, though, the CFTC is this reputation that insider trading is a free-for-all in part because of trading places. In Dodd-Frank, we changed that. We created the Eddie Murphy rule that says you cannot do insider trading off of government releases. And then the CFTC, this might have been under you, Chris, did 180.1, which said this applies to not government releases, too.
For the younger folks here, you got to
Yes.
tell them to watch Trading Places.
It's a great movie. No, I watched it with my family. My kids hated it. But it is the case, right? This is another example of how the CFTC is adapting to the times, trying to expand its mandate. More can be done. More can always be done. There's a role for the private sector, but it's not as though this is starting from a dead stop. They've been making progress on this for 15 years now. Chris, you want to say something?
Yeah, I do. So what's happening right now, we've got a conflict in the Gulf, and where is actually the trading taking place? Not in prediction markets, but in the good old-fashioned oil futures markets. Well, those markets are, guess what? They're not on a blockchain. So if you're going to do insider trading, you don't want to go to a blockchain-based prediction market like a poly market, because while they might have a little harder time getting to you, they know exactly who's doing it because on a transparent blockchain. If you're going to insider trading, go back to the old-fashioned market. So insider trading is nothing new. People trying to take advantage of information in violation of a duty the CFTC can go after. What's different about these markets is law enforcement will love it if you do it on a blockchain-based prediction market, because they're going to catch you. So, look, it's a new technology. All the things we're talking about, whether it's prediction markets, whether we're talking about perps, we're talking about stable coins earlier today with Senator Hegarty, all of this is part of this new wave of the internet, an internet of value that is coming about. Finally, the internet is getting to do to financial markets what it's already done to information gathering and everything else. And these are new technologies. And just like 30 years ago, Washington came to accommodate this, we're now doing the same thing here.
This gets at something which I think a lot of policymakers don't get yet. Part of why there's so much excitement, or there should be, for on-chain data, for data in prediction markets that's on-chain as well, is everything is then now in one format that can be read by agents, AI agents, and you can then have much better, faster surveillance for the first time. What has bedeviled us for 20 years now is we have a wealth of computer data, all in different formats. It basically becomes garbage. When you put everything on one or two standards, you then can actually have, for the first time, real-time surveillance and better enforcement. This is a win for American consumers. And it's one thing that I've been surprised at how a lot of regulators don't get. I think in part, and I know a lot of us are lawyers are bad at coding, and this is scary. But as a result, if you can really embrace this, you can 10x the ability of regulators to actually protect their markets as well.
And we've got firms like TRM Labs. They are providing the type of surveillance on these blockchain-based systems where actually you're going to find the bad guys are going to not want to be on them. They're going to go to closed systems because in open systems they're going to be found out.
I agree with everything that everybody said. I just want to add one other thing, which is there's market manipulation authority as well at both the CFTC and the SEC, and that is a good complement to the insider trading authority. And again, with transparent blockchains, seeing the manipulation happen in real time is huge advantages. So I think 100% insider trading enforcement coupled with market manipulation enforcement, you have two very powerful tools.
Wonderful, and I believe we are right on time, and the mics don't work, but that's okay. So thank you so much to all of you. This was a great conversation. Really appreciate it.